Good evening. Welcome to the first episode of When the Gavel Strikes. My name is Cherie Morris. I am the principal attorney for my law firm, the Law Office of Cherie Morris. I am a licensed practicing attorney in Alabama, Georgia, and Mississippi. I have been practicing law for 4 years now, and I have three primary practice areas of real estate, personal injury, and family law. In tonight's live episode, what I'm going to do is talk about the top 5 most common questions that I get in the areas of personal injury and family law. So I'm going to start with family law, and so let's dive in. The first question I want to mention is, what factors do courts take into account when making custody and visitation decisions? Well, that answer varies from state to state. However, some of the factors are common to every state. So the top one I think that most courts would consider is relationships. So they look at the relationship with the parents. They look at the relationship with siblings, if there are any. They also look at the relationship of any cousins, aunts, uncles, grandparents, anyone like that. They also look at the relationship the child has in the community. So if there is a big family presence, if the child is very active in school, in the community, those factors tend to weigh heavy as well. Another factor that they tend to think about is the financial and living situation of both parents. So if one parent is more financially stable, or one parent can provide a better household, or say for instance one parent cannot provide a household for the children, then that is definitely a determining factor. And the amount of income varies. The court is not going to say because one parent makes $10,000 above the poverty line and the other makes $50,000 above the poverty line doesn't mean that the one with the higher income will get more weight. So that doesn't matter. Another factor is they look at how the parents build the relationship with the other parent. So if you have one parent who's very vindictive and who is talking negative about the other parent, that weighs a lot in court, especially to a judge when the parents cannot agree. So you can't be out there, bad mouthing one parent to your child and trying to get custody in that way, because it's not going to bode well for you as the parent. Another factor, it doesn't weigh as heavy, but they do look at the child's age. They look at the child's educational needs. So if you have a child who has special needs and one parent lives in a school district where they have a great program for that special needs, that's one factor that will weigh heavily. If the child is, and this age varies by state to state as well, so if the child is 12 years old, in most states, the judge will consider that child's choice as to which parent they want to live with. So that number is usually the same around every state, but 12 is kind of the magic number, 12 and 13. So those are most of the factors that most courts consider when determining who gets custody. So let's move on to the second question. The second question is one that is an age old, and it says, are mothers more likely to be awarded custody over fathers? And that answer is a big no. Those days are long gone. Now, even if the child is a newborn, that child can be placed with the father if the mother is determined not to be a good fit for custody. So no, the law does not favor mothers over father. The law favors what's in the best interest of the child. That is the most important thing that most parents need to remember when going through a custody situation, because if the judge doesn't think it's in the child's best interest, the judge is not going to award it, even if you guys agree. So just think about that when you're going through the custody situation, or even if it's a custody situation that involves a divorce. You always want to think about what is best for your child, not what's best for you. So moving along, the third question is, do I have to pay child support if my ex keeps me away from the kids? That answer is a big yes. You have a legal obligation to support your children financially. It doesn't matter if it's coming from the father or the mother. By law, you are required to support your children financially. So if your ex is keeping you from seeing your children and you don't have a court order for visitation or custody, you need to get one as soon as possible. If you do have a court order for visitation or custody and your ex is not allowing you to see the children based on that order, then you have what's called a contempt action. So what you would need to do is bring that ex back to court and let the judge know that they are not complying with that order. And there can be all kinds of consequences for contempt. There could be financial consequences, there can be jail time consequences, there can be a consequence of actually losing custody of the children. So what you don't want to do is stop paying child support because you're not seeing your kids, because at the end, you're going to be the one that's suffering from it, because you could go to jail for not paying your child support. You could be fined for not paying your child support. And it's not going to really bode well for you if you, in the long run, try and see your children or try to get visitation or even custody if you have not been paying child support. So keep your child support payments regularly, but fight through the court to see your children on a regular basis. Don't fight with your ex, because that's also not a good situation. The next question is, if I have sole custody of my children and my ex, who lives in another state, has threatened to go to court in his state and get custody and get the order changed, can he do that? So the answer to that question is, of course, no, he can't do that. Wherever a court order was decided when it comes to child support and child custody is where that court order stays. So if you live in Georgia and you and your ex got a court order for custody or support, Georgia has what's called continuing jurisdiction. So that means nothing can happen to that court order without you going back to Georgia and getting it changed. So in this situation, if her ex does not bring the children back on time on multiple occasions, she has a right to go and file a contempt action. So the contempt action, again, is where she goes back before the court and let the court know that her ex is not complying to the order, and let the judge punish him or penalize him for whatever reason. And again, in that situation, 9 times out of 10, he would probably lose his visitation or custody rights, or the judge can switch over visitation to make it supervised. So he has to come to a certain area, somebody has to be there, and it has to be between certain times. So no parent wants to have supervised visitation of their kid because they feel like it's overstepping their bounds, which I can understand. So you do want to comply with any court orders so that a court doesn't step in and take away your rights as a parent. So the last question for family law, it says, I have sole physical custody of our children. Several times, my ex has not returned the kids on time after taking a visit, and I'm scared he won't return them at all. So same question, same answer. Basically, the ex can't do anything as far as changing the custody order. If she feels like the ex won't bring the children back on time, just take them back to court, have a contempt action. And I'll do one more question. It says, under what circumstances can custody orders be changed within the state where they were obtained? So, like I said earlier, wherever you got your court order is where you will have to get it changed. So, this answer also varies from state to state, but most times you can get it changed if there's an emergency situation. So, say for instance, one parent has a strong financial hardship and the children need to leave that one parent and go stay with the other parent. So that's an emergency situation. If there's an abuse situation, that's an emergency situation. If there's a neglect, that's an emergency situation. Other times, and most often, which is common, is by agreement. So if later on down the line, you say you had a custody order when your children were 5, 6, and 7, and now they're 13, 14, and 15, and they live with their mother all this time, and now they want to go live with their father, and both of the parents agree, then they can just come back and do a joint petition to the court to say, hey, our children want to change custody. We agreed to change custody. We need an order saying that we can change custody. So the most common ways are by agreement and in an emergency situation. And anything that anything that involves neglect, abuse, abandonment, or financial hardship is always going to be an emergency situation. Okay, so next, let's switch over to the personal injury side. This is the fun part. Okay, so the first question says, I was in an accident and my friend was at fault. How can I get compensated but not hurt my friend in the process? So in that situation, if you are a passenger in a car with your friend, parent, relative, whoever, and you are injured, you have a right to be compensated because you're just a passenger. You're not the person at fault or anything like that. So in that situation, you would file a claim with your friend's insurance company, letting them know that you were injured in that car. It doesn't matter that she was at fault because it's determined she's at fault. So she has to be responsible for any injuries occurred, whether it occurred to another victim on the other side in another car or whether it occurred with anyone in her car. So you're not going to lose your friend or hurt your friend by filing a claim through your friend's insurance company, because that's what we all pay car insurance for if anyone is injured, even yourself. So if I was injured in a car accident and it was my fault, my insurance company can still pay me for my injuries because that's what I pay insurance for. So you're not going to lose your friend if you have to file a claim through her insurance company. And even if it goes so far as to filing a lawsuit, at the end of the day, it is the insurance company that is being represented there. Your friend is just on paper the defendant. So your friend is not going to be responsible for any money. Your friend is not coming out of pocket for any money that is being given to you. So don't feel bad for having to file a claim. And if they're really your friend, they're going to tell you to file a claim anyway because they don't want you to be hurt. Okay, so the next question is, I was in an accident, but the person who caused it doesn't have car insurance. What do I do? So this is a good question. And this is something that everyone needs to go and look at their car insurance policy and see if they have it. It's called uninsured or underinsured motorist coverage. So in most states, not all states require, but most states require you to have some amount of underinsured or uninsured motorist coverage. And what that means is, exactly in this situation, if the person that hit you is responsible and they don't have car insurance or they don't have enough car insurance to cover all of the damages that you have incurred, you can get that money from your own personal insurance company. That's where your uninsured or underinsured motorist coverage come in. So check your policy and make sure you have it. So if you don't have it, you had to physically sign a waiver saying, I do not want this. I know I should have it, but I don't want it. Most people don't go through all of that, but just double check to make sure you have uninsured, underinsured motorist coverage. And I have seen on several different occasions where that money has come in handy. So say, for instance, someone has a basic minimum policy of $25,000. That means $25,000 is all the insurance company is required to pay out of their pocket. So say you incur medical bills and damages worth $50,000. Well, from that other person's insurance company, all you're going to get is $25,000. Now, what you could do is submit that information to your insurance company and say, hey, I have $100,000 in uninsured motorist coverage on my plan. I need $25,000 to cover my injuries. And you'll have to negotiate with them. Most lawyers do that negotiation for you if you have a lawyer. You'll do that negotiation with them. They may give you a check for the whole 25. They may want to see what your injuries were and negotiate down, or they may give you more depending on what you ask for. So underinsured or uninsured motorist coverage is very important. So If you have it, make sure you have enough coverage. If you don't have it, make sure you get it, because you don't want to be caught in a situation where you don't have enough money to pay medical bills or lawyer fees or anything like that. And then everybody wants to have money to walk away with in an insurance claim. So make sure you have enough coverage there to cover you. And another point I want to talk about before I move on to that question, because it's related, is in most insurance policies, they have medical payments coverage. And what that means is if you're in an accident and say you immediately go to the hospital and your bill is $5,000, and say you signed up for $10,000 worth of medical coverage, your insurance company is required to write you a check, write your lawyer a check, or write the facility a check to cover that $5,000 in medical payments, so that doesn't come out of your pocket and it doesn't come out of any settlement money that you get later on down the line. So that's another thing you want to think about, is medical payments coverage. Now that is definitely optional. It's not required by law or anything like that. So, and you can pick however much money you want to pick for that. So most of them start at $1,000. Some go all the way up to $100,000. So it's your choice as to how much coverage you want to have. But that's another good point. And it also increases the amount of money you get too, especially if you let your lawyer get it. Okay, so the next question says, what does the insurance adjuster say that they can resolve? Why does the insurance company say that they can resolve my case without involving an attorney? So this is a trick that the insurance company like to do, because they don't want to get lawyers involved. One, because lawyers go to court. The more money the insurance company has to pay out, the less it looks like for the less bonuses the adjuster gets. So the adjuster is trying to pay the lowest amount of possible with you. So early on in a case, say you've been out of your accident maybe 2 or 3 weeks, you've gone to the doctor maybe once or twice, and you haven't really, gone to any more treatments. The insurance adjuster will call you within those first few weeks and try to get you to settle as soon as possible, because most times people settle really quickly because they need money, and they don't realize that they can get way more money than what the adjuster has given them. So say for instance, you're in an accident, a rear end accident, and your car, it's not total, but say you have about $5,000 worth of damage to your car. You got minor back pain. It's not major to where you have to have surgery, but it's minor in a sense that you have to rest for a couple of days. You need to go see a doctor to make sure everything's okay. So in that situation, an insurance adjuster might call you and say, well, I'll give you $5,000 to settle your case today. Most people are like, great, $5,000 is, I didn't even think about that. I needed that money. So they'll say yes. When if they had went to a lawyer or prolonged it a little bit better, that $5,000 could have been $15,000. It could have been $25,000. And the facts of the case determine how much money you get. So, but you never know how much your case is worth unless you consult with an attorney who knows how to get high settlements, who knows how to instruct you, how to guide you through the process. So you don't ever want to listen to an insurance adjuster saying, I can do this without an attorney. The only time you want to do it without an attorney is if you have no damage to your car. And when I say no damage, I mean a scratch, something that can be easily buffed out, anything like that. You have very little pain, like you might have gotten a little whiplash in those 2 minutes that it hit you, but you're fine after you've, sat there. But those are the only times you don't want to get a lawyer involved, because you have a very, very low value case. And in that situation, when I say low value, I mean you're getting $3,000 or less in damages. So in that sense, you don't really want to give a lawyer, a doctor, and yourself, you don't want to divide $3,000 between all those people, because you're not going to get any money if you get anything. So if you have no property damage to your car, you have no injuries, or if you don't go to the doctor at all, you don't want to get a lawyer involved, because that's something you can get yourself, get the $2,000 or $3,000 and be done with it. Okay, so the next question, it says, what is the most important thing for me to do after my injury? So the most important thing any lawyer will tell you is to go to the doctor. Go to the doctor, go to the doctor, go to the doctor. Do not miss any visits. Don't go to the doctor and say, well, I'm really fine. I don't have to come back here anymore. You let the doctor tell you that you're fine. You let the doctor give you what's called a medical release. And the doctor says, we have done everything we can do. You're at your maximum improvement level. There's nothing else for us to do. You're pretty much healed. That is the only time you want to stop going to the doctor. But other than that, the most important thing to do is go to the doctor. If you don't have a medical doctor substantiate your injuries, it's going to look like, one, you weren't hurt, or two, you weren't hurt very badly. And those are the two most used ammunitions that the insurance company has. So you don't want to let them discount your injuries at all. So go get treatment, as much treatment as you need, but be reasonable and don't over exaggerate your injuries, but don't under exaggerate them either. So the last question is, and I get this all the time, when will my case settle? So the usual timeline in a personal injury case is, the first thing, the accident happens, you get the police report, you go immediately to the doctor. You want to go to the doctor within 24 to 48 hours of your accident. Anything after 48 hours becomes very difficult for you to prove your injuries and substantiate your injuries, and it's even more difficult for a lawyer to negotiate. So you want to go to the doctor within 24 to 48 hours. After you go to that initial doctor's visit, you want to follow up with your primary care doctor. You want to let your primary care doctor give you a full examination and ask them for what their recommended treatment is. Most times the recommended treatment is to go to a chiropractor to do physical therapy, or you're going to need some sort of surgery or some sort of injections to the pain site. So if you're doing physical therapy or chiropractic treatments, most of those treatments last 6 to 8 weeks. So it's not until you finish that treatment and you have been released from your medical doctor to say you are fine, we've done all we could do, you're at maximum improvement. It's not until then that a lawyer can send what's called a demand letter. And the demand letter is basically a pre-argument to the insurance company saying why their insured is at fault, what kind of damages you incurred, what kind of injuries you incurred, all the money that you have had to spend, all of your pain and suffering. So that's the letter that they argue with, and they ask for whatever amount of money that they think is reasonable. And most times your lawyer should talk to you about what that amount is before they send it. Sometimes they don't, but you want to make sure that you are comfortable with the number that they are asking for. And if you're not comfortable with it, you need to understand why your lawyer is asking for that number. And it may be something that you need to adjust, or it may be something that you haven't told your lawyer that your lawyer didn't think about when coming to that number. So at that point, when the demand letter is sent, the insurance company does their own evaluation. So they have all the medical records, the police report, the medical bills, and everything. So they do their evaluation. That turnaround time is usually about 30 days. So now we're like we're into month 3. So once the insurance company comes back with their counter offer, unless you have a extremely easy case, and when I say extremely easy, means your accident was really bad, you had to get an ambulance to go to the hospital, you had surgery, you had all these things and all these injuries, all these ailments, then the insurance company 9 times out of 10 may just give you a check. But if you don't have something substantially difficult to deal with, something substantially burdensome, or something substantially wrong with you, and when I say that, I mean like you have a broken wrist, a broken finger, you broke your arm, your knee, you tore your ACL, you popped a disc, anything like that that requires immediate surgery, 9 times out of 10, the insurance company is going to come back with an offer that is significantly lower than what your lawyer asked for. So at this point, the lawyer and the insurance company are going back and forth negotiating. So in most states, and I know here in Georgia and in Alabama, the lawyer is required to let their client know what offers the insurance company has given them. Even if the lawyer thinks that it's pretty stupid or that is basically a slap in the face, they don't care, the lawyer is still required to let the client know, hey, they came back to us with this ridiculously low offer. I think we should decline it. Just wanted to run it by you. So, of course, most people would say, yes, let's decline it because we think we can get more, blah, blah, blah. So the negotiation can go as soon as a couple of days or as long as a couple of months. So unless and until you and the insurance company and your lawyer reach a number that you can all live with and agree with, that negotiation is going to go on until the lawyer says, you know what, we're not going to get any further, or the insurance company says this is our last and final offer, we're not going any higher. Until you get to that point, it can go on for as long as they want. But once they have given you their final offer, then you can either say, I'm done with the case, I don't want any money, or you can go and move on to litigation and file a lawsuit. So, in short, if you settle your case before filing a lawsuit, you're looking at 3 months to 6 months, considering how bad you're injured and how well your treatments go, and if you don't miss any treatments, you don't miss any visits. So 3 months is the shortest time, and I say that because you need 6 to 8 weeks to go to your chiropractic treatments or your physical therapy treatments. And once those treatments end, then they have to send the medical records. So when the medical records come in, everybody's ready to rock and roll. So that's the easiest and quickest way. Now, if you have some more difficult injuries or longer injuries that require longer times to treat, then you're on that 6 months time frame. But as long as you're finished treating before that 6 months time frame, you got maybe an additional 30 days, maybe 2 more months before you can settle your case if the insurance company gives you a number that you like. So that's before settlement. So after settlement, so if they don't agree on a number that you agree with, then you have to file a lawsuit. And this is when your case slows down. So a lawsuit can take anywhere from 6 months to 3 to 4 to 5 years, depending on how bad you are injured. So if you have a relatively low amount of damages, which is, let's say you only have about $10,000 worth of damages, worth of medical bills and pain and suffering, anything, you have about $10,000, you can file a lawsuit in what is the equivalent of the small claims court. And what that does is it gets you in front of a judge a whole lot faster. You don't have to have a jury trial. You're just presenting the facts of your case to the judge. You get on the witness stand, and your lawyer is going to guide you on what to say and, how to answer questions and things like that. And you answer those questions in front of the judge. And the insurance company's attorney will get up and ask you questions. That's called cross-examination. And so once that process is done, the judge will listen, and the judge will make a determination as to whether or not you get any money or how much money you get, or if you get what you've asked for. So that's the quickest one. And those are usually anywhere between that's in the first 3 to 6 months. So if you have a lot of damage, say you're in the 20s, 30s, 40s, or 50s, then you are going to go to a higher jurisdictional court. And what that means is it's going to be some intermediate level or some higher level. So the names of the court vary in certain states, but they are a higher jurisdiction. That means you can get more money in these courts. And in these courts, they require you to do a little bit more of litigation work. So that's why it takes a little bit longer. So they have what's called a discovery period. Discovery is where both insurance companies and the lawyer, or both lawyers at this point, both lawyers exchange information on their clients so that each lawyer can begin to prepare their case. and to know how to present the case to the judge, how to defend the case if they're on the other side. So that discovery period usually lasts about 6 months. So once that discovery period is over, then we get to what's called mediation. And mediation is sometimes required in some courts, sometimes it's not, it's just suggested. But most times you go to mediation, and you can usually settle your case in mediation. And in mediation is basically you and your lawyer and the insurance company's lawyer and someone from the insurance company. Most often it's someone from the insurance company that can write a check that day. So you want to have those people there. And the two of you or the four of you are sitting with a mediator who is a neutral party who will listen to each side and try to convince each side to settle. So the mediator is not a judge. It's not binding where they're required to do anything. So the mediator is just a person there to help facilitate the settlement discussion. So once mediation is over, say we didn't settle in mediation, then we get to pretrial conferences. So what a pretrial conference is, where the two lawyers from each side come to the judge and say, Judge, this is how we want to present our case. This is the time frame. These are the people that we're going to call. This is the evidence that we're going to present. So once you get past the pretrial conference, then you get on what's called a trial calendar. So this is where your time waits comes from. Some courts, you can get on the trial calendar within a month. Some you don't get on until 3 months. Some you don't get on until 6 months. So it just depends on when that trial calendar is available. And then even on the trial calendar, you can say, okay, my trial starts March 1st or the week of March 1st. If you're not first on that trial calendar, say you have about 5 people before you, you cannot go to trial until those 5 trials have completed. So even if your trial calendar is March 1st, you might not actually get to trial until March 25th. So if you're in litigation, be prepared for the long haul. So that wraps up all of my questions and all of my discussion today. If you have a question that I did not touch on or did not talk about, feel free to leave me a comment and I'll respond back to you in your inbox. And if you want to know more information or want to speak with me or want to check out all of my sites, I am at Cherie Morris Law on Facebook, Instagram, Twitter, Google+. And if you want to reach me by phone, if you're in the Georgia area, you can call me at 770-966-3244. If you're in the Mississippi area, you can call me at 601-460-1779. If you want to send an email, it's Cherie, Shari, at CherieMorrisLaw.com. And also check out my website, www.CherieMorrisLaw.com, for more information. Thanks for watching, and tune in next month for our next session of When the Gavel Strikes.